Hello everybody. Thank you for joining us today for this webinar by HR Solutions on handling a sexual harassment complaint. A really warm welcome to everybody and a thank you to all who are joining us today. We're going to start by introducing ourselves, if we may, just for those who haven't joined us before, and so you can know who we are and who you're listening to. My name is Abby Ashford and I am a HR consultant for HR Solutions, and I shall be the lead presenter for you today. I'm joined by my colleague Ateem, who is our digital marketing executive. She is here to field any technical problems that there may be, hopefully none of course, but that is what the control panel is for. On the side of your screens, you can use this to interact with us, ask questions and note any technical blips that we may be able to assist you with in the background. A team will be monitoring and collating questions, so do please feel free to send her a message and then I will email you a response after the webinar is concluded. As always, we are recording this session, so it will be available for you to watch again if you wish to, and to share with colleagues if that would be helpful. If anyone wants to contact us afterwards for a copy of the presentation slides, then please note that you are very welcome to do so using the inquiries email address confirmed at the end of this webinar. On to the subject in hand today then. I am presenting on the very topical issue of handling sexual harassment complaints in the workplace. And 5 bullets appearing on your screen show you the areas that I will be covering. After introducing the subject matter, I will take you through what process should be used to manage such a tricky complaint when it comes in, how to strike the right balance where you often may have one person's view against another's, concluding with what legal changes are ahead of us in the field of sexual harassment, and a summary of the material presented today. As a viewer and a listener to this webinar today, it is useful upfront to convey what our aims are. And by the end of the webinar, you will hopefully feel that we have clarified the definition of sexual harassment by giving you some live examples, confirmed the best way of dealing with such a complaint, given you a way of considering how to strike the right balance when dealing with potentially opposing views of what has happened at work, and alerted you to upcoming legal changes. I expect this webinar will be about 45 minutes or so. And so on to my introduction. All right, so let's start by having a little look at the subject matter of sexual harassment in the workplace. Sexual harassment is a form of discrimination and can be a criminal offence. It can be a single act of unwanted treatment of a sexual nature that may degrade, humiliate, offend, or intimidate someone, as defined by the Equality Act. ACAS explained that sexual harassment can happen in a number of ways, including written or verbal comments of a sexual nature, such as remarks about an employee's appearance, questions about their sex life, or offensive jokes. Displaying pornographic or explicit images, emails with content of a sexual nature, unwanted physical contact and touching, and sexual assault. So, with that definition in mind, I'll move on to our next slide. And this is our first poll of 2 today. Your first question that I'm posing to you is a scenario where it becomes known to you that a male employee has formed a habit of exposing his behind to his colleagues, both male and female. Do you think that this would be viewed as sexual harassment? If you'd like to select either yes or no on the panel to indicate your thoughts now, please. And we'll see what percentage thinks that it does or doesn't constitute sexual harassment. I'll just give you a few minutes to collect your thoughts and select yes or no. Don't worry, I won't see names against who is indicating yes or no, and so won't be saying any names on this webinar, please be reassured. Okay, it looks as though the majority of you have selected a response, and so I will conclude for you that 100% of you have said yes, it is sexual harassment. Of course, the answer to this one was that it was deemed sexual harassment, as it is down to the person who is on the receiving end of the behaviour that determines whether they feel it was unwanted and that they felt it created an offensive environment. The key learning from this case is that it is down to the individual as to whether they felt the behaviour was unwanted and found it offensive. Often cases like this appear at tribunal because the person who presented the unwanted behaviour thought it was banter, but the recipient disagreed. Employers are required by the Equality Act 2010 to take appropriate steps to prevent sexual harassment from occurring at work in the first place. If they do not do this, they can be held legally responsible if an employee is sexually harassed at work. To prevent harassment, an easy and important starting point is to make it clear to workers the types of behaviour which would be considered unacceptable and what behaviour would be deemed sexual harassment, such as those listed on the previous slide. For example, written or verbal comments of a sexual nature, questions about their sex life, offensive jokes, displaying explicit images, and emails with sexual content, unwanted physical contact, and of course, sexual assault. So what process should be used to handle such a difficult matter? Remember, we are talking about handling something extremely sensitive that may have affected someone both physically and mentally, and how it is handled will impact on those involved, their emotional state, their confidence in their employer, their future employment with you, and so on. It goes without saying that right at the top end of the scale of sexual harassment situations, if you are dealing with one at work that involves sexual assault or a physical threat, these are criminal matters that should be reported to the police. You would need to call 999 where there is immediate danger or the crime in progress, or call 101 if the situation was not an emergency. It is imperative that the right process steps are followed when handling a sexual harassment complaint. So let's have an in-depth look at this aspect. Many employers advise their employees to raise a complaint through the grievance procedure. And this makes sense, especially where there is no separate harassment policy and procedure. Indeed, many employers who do have a separate bullying and harassment policy detail a form of grievance procedure within that policy anyway. So, to be clear, it is a grievance procedure that we need to utilise here. Managers should be following the internal formal grievance process to structure the way the complaint will be handled. This is an important point because many managers will immediately think they need to suspend and investigate the person accused of sexually harassing as the first step. But in actual fact, when using the grievance procedure, there are other initial urgent requirements, and you need to grab a copy of both your grievance procedure and your disciplinary policy in order to plan how best to deal with this situation at hand. Imagine you are tasked with managing a sexual harassment complaint at work. Let's run through how this would work in practice. Where there has been wrongdoing, you will effectively be running a grievance process in conjunction with a disciplinary procedure. Firstly, you will receive a complaint. This might be verbally, written, by email. A complaint of sexual harassment is sufficiently serious enough that it should be treated as a formal grievance where possible. Secondly, the individual who raised the complaint must be invited to a formal grievance hearing without delay. Thirdly, the grievance process would then require you to carry out any further investigations that are necessary. An investigation is also the first stage of a disciplinary process, so the third step is a thorough investigation. Fourth, where it is found that there is a case to answer, there must be a formal disciplinary hearing arranged and conducted. Fifth, an appropriate outcome to the hearing is issued. Sixth, a written conclusion is provided in response to the complaint wrapping up the grievance process. And lastly, any appeals that might be submitted from either the disciplinary or the grievance outcome should be dealt with accordingly. Gross misconduct is behaviour that was malicious, willful, intended to cause harm, and so where allegations may amount to gross misconduct, suspension or an appropriate alternative where possible will need to be arranged without delay. This can be tricky because in a disciplinary process, you would ideally have at least a preliminary investigation meeting with the accused to find out if they can quickly exonerate themselves before suspending them. However, when a grievance is involved, you would ideally hold a grievance hearing with the employee who made the complaint before investigating with others. This makes the timing of a suspension tricky. You may try to engineer the situation so as to keep the two parties separate for a brief period prior to the grievance hearing, but it becomes imperative that no time is lost in setting up a grievance hearing and ideally an investigation meeting with the accused shortly afterwards. If delays are anticipated, then suspension or an alternative may need to happen first. We are often asked what to do in a situation where the employee does not want to make a formal complaint. This might be where someone has disclosed private information to you, simply wanting to offload how they are feeling and looking for empathy and support. They may even say that they are not confident enough to take the matter further as they are scared of what may happen. However, employers have a duty of care to all employees and workers and must take a zero tolerance approach. So even if a complaint is not raised formally, all harassment allegations which are brought to your attention must be investigated thoroughly, regardless of whether or not the individual concerned wants you to take action. And this is because employers have a duty of care to protect the member of staff, as well as other employees, and to prevent further harassment or even victimisation. If you failed to investigate the allegations and then a further person fell victim to sexual harassment at work, the liability would fall directly with the employer for not having attempted to prevent further distress. It is the job of a manager to exercise the employer's duty of care towards both parties. This can make managing such sensitive allegations particularly tricky. Therefore, it's important to consider ways of striking a sensitive balance that is required in these types of cases. So let's have a look at the working environment. Firstly, employers need to create the right environment, and it goes without saying that bringing up a complaint about sexual harassment to a line manager can be difficult and even distressing for the employee. Consider how this can be made as easy as possible. We have the following tips to help beat the fear of reporting. Publish a clear zero tolerance statement and circulate it to all staff. Be sure that all your staff know of 2 senior people that they should confide in if needs be. Ensure you have a grievance policy. Check it is reader friendly and sets out clear steps which someone in distress will feel are achievable. You may even have a separate bullying and harassment policy. The policy should not deter people from coming forward, i.e. explaining dismissal is a possible outcome for the accused, but this may create feelings of guilt about reporting, so consider putting these outcomes in the disciplinary policy instead. Adopt an open door approach to encourage employees to speak with their line managers. Explain what to do if harassment happens and raise awareness to your policy. Invest in training for both managers and staff so that they can recognise harassment, deal with it effectively, and even avoid becoming a perpetrator inadvertently. Explore unexpected resignations, especially any that allude to a workplace issue. And look into stress-related absences and ask if there is anything going on at work which you should know about. Communicating the approach. Once you become aware of a complaint, managing it closely should become an absolute priority. Employers should follow their policies, but they should also ask the employee if they are comfortable with the intended approach and what their ideal outcome would be. This would give you a good idea of what to aim for in order to satisfactorily improve the situation for your employee. You also need to explain the process you intend to follow in accordance with your grievance or your harassment policy to both parties separately. This should reassure both parties that a fair process will take place and helps to manage their expectations. Speaking to the accused employee before involving others. After the meeting has been held with the employee who has brought the complaint, it is crucial to attempt to speak to the employee who has been accused before speaking to any possible witnesses or involving too many managers. It needs to be contained. This is because the individual may be able to quickly exonerate themselves, removing the need of involving others. Involving other people in such a sensitive matter unnecessarily can have a profoundly negative impact on the employment relationship with the accused and could begin to make it untenable for them to continue to work there, especially if they were actually innocent of the allegations. Taking into account that both parties may become distressed throughout this process, the individual who suffered the sexual harassment may be feeling extremely vulnerable or even unsafe at work and on their way home, and it may have a serious impact on their emotional state. It is perhaps less often thought of, but the accused may also become highly distressed. Employers need to take appropriate responsibility for the welfare of both parties. It is important that they both understand the approach that is being taken, i.e. that first and foremost a thorough and fair investigation into what is alleged to have happened will take place before there is any further action. Always think through at the outset of such a case who the most appropriate managers are to oversee this case. You will need at least 2 impartial managers to deal with this, holding back your most senior person for any appeals. This can be very difficult in family businesses, where everyone is either closely related or part of a network of friends. Sometimes outside support is necessary. It is a good idea to check that the person bringing the complaint has someone in their home life to support them. Similarly, once the accused has been advised of the allegations, it is worth asking if they have a family member or friend they can call if they should need support. Both parties should be provided with the contact details of any form of employee assistance programme you may have in place, such as counselling helplines or appointments that can be made to receive support. It is worth asking both parties if there is anything that could be done to help them to feel more at ease whilst the process is ongoing. For example, how any absences are communicated to other staff, whether any temporary change to working patterns or work location with the business can reasonably accommodate, may be helpful for their welfare. However, be careful about only moving the person that raised the complaint, as more often than not, this will be a female member of staff, and we don't want the wrong message conveyed. Striking the right tone. The tone of language that should be used in any questions at the grievance hearing and subsequent investigation, or in any letters sent, should be fact-finding and exploratory in nature, and must be sensitive where appropriate. Nothing should be accusatory as you are fact-finding at this stage. Should the process move on to the disciplinary stage, the tone would change in a disciplinary hearing. If investigations have uncovered that there has been misconduct and there was a need to take formal action, the invite to disciplinary will contain the allegations against that person, and the hearing will contain questions to try and get to the bottom of what has happened. Open questions and probing questions will be required based on the allegations and evidence in order to come to a conclusion and an outcome at the end. Striking the right balance can be difficult where different perspectives are being portrayed to you. Often it transpires that there is a huge difference actually between how the intention of an act of behaviour and how it was perceived. In the same way, some behaviour may be considered relatively minor to some people and very serious to others. The person accused can often be completely shocked that they are being complained about, as no one has ever accused them of such behaviour before. Whilst the viewpoints of everyone involved in a situation should be taken into account, ultimately, it is the perspective of the person who received the treatment that counts the most in the eyes of the law. And this is why it's crucial to remain impartial and to take the points being made to you by the victim seriously. It is not for you to judge whether they have been sexually harassed or not. If they say that they feel that they have been sexually harassed, then they have, and you have to deal with it without judgment. Often the outcome is one of the most difficult parts to conclude on if you have differing views and yet still need to repair a salvageable work relationship where no one is being dismissed. Depending on the severity of the situation and the will of the complainant, it may be possible to repair minor situations with facilitated meetings. A facilitating meeting can be arranged so that the employee and the person they accused of sexual harassment are in the same meeting room with an impartial person appointed to mediate between them. Mediation will involve asking the employee to depict what behaviour made them feel so uncomfortable at work and how they would want the person accused to amend their behaviour. The person accused would be expected to offer some form of olive branch by way of an apology for their behaviour, making the employee feel uncomfortable, how it wasn't intended, and how upset they are that they have made someone feel this way unintentionally. The employees would then agree on a way of working together in the future, and agree that if either party has any worries, to come to the other to raise with each other if they feel okay to do so, or if not, to come back to the mediator or their manager. In some cases, professional mediation can be more appropriate, where there is no option in-house. The approach should be offered to the member of staff who was harassed and then mutually agreed. No one should be forced into a mediation situation, as it just won't work unless both parties agree to work on a resolution together with assistance and support. Okay, on to our second and final poll. And this one is quite a different but still very interesting case. And this is one where a female employee gave an unwanted massage to a male colleague on his neck and on his shoulders. Please, again, would you use your side panel to indicate whether you think this could be defined as sexual harassment? It's an interesting case. This actually happened and was the result of an employment tribunal case. It will be interesting to see how you vote on this one. I can see that you're selecting your responses. Thank you for taking part. I'll just let the last few people choose an answer. Okay, it looks like most people have had a chance to vote. Let's have a look at the results. Well, it seems 91% of you said yes and 9% of you said no. Well, I am not surprised by these results, as this employment tribunal case did go to appeal. And perhaps surprisingly, the appeal found that it was not sexual harassment. This was the case of Raj versus Capita Business Services Limited and Miss Ward. Well, if you remember from one of my first slides, the definition of sexual harassment from the Equality Act is that it is unwanted treatment of a sexual nature that may degrade, humiliate, offend, or intimidate someone. And the key part of that sentence for this case was the sexual nature of the conduct. The appeal tribunal decided that there was no evidence that Miss Ward, Raj's team leader, had behaved like this to any other employee, male or female, and that the contact was with a gender-neutral part of the body. So the neck and shoulders were deemed gender-neutral. They concluded that Miss Ward's behaviour was unwanted conduct, but was not sexual harassment because of the part of the body that she had touched. Interesting. Okay. A number of consultations have been underway over the past 12 months, which look to improve the way UK law protects individuals against sexual harassment in the workplace. As a result, the following changes are on the horizon for the future of HR practice. We have a new statutory code of practice and a new legal duty on its way. Plans have been announced to introduce a new statutory code of practice on sexual harassment to be developed by the Equality and Human Rights Commission, and in response to concerns raised by the Women and Equalities Select Committee. The code is intended to support employers to better understand what is expected of them by law and to help them ensure that they have the right preventative measures in place. They have also proposed the introduction of a new and specific legal duty on employers to prevent sexual harassment in the workplace in the light of the Me Too movement. The government has acknowledged that whilst sexual harassment has been covered by legislation and therefore prohibited for many years, it is still rife and coming to the fore through the Me Too campaign. Therefore, this code of practice, in conjunction with employers and the Human Rights Committee, will strengthen the legal position and raise awareness further of the kind of behaviour that simply cannot continue to occur without being brought to account. Extending time limits for claims and the scope of protection. The government are reviewing public feedback on plans for an extension of the 3-month time limit to bring a discrimination claim in tribunal. So that's any claim covered by the Equality Act. How to strengthen and clarify the laws on third-party harassment in the workplace, which was previously dropped by the coalition government of 2013, and whether interns and volunteers require further legal protection. Excuse me. Confidentiality clauses, preventing misuse. As a direct result of the Me Too social media campaign, you will find that many solicitors in the UK now will not accept work from those wanting an NDA drafted to do with sexual harassment. Although clauses and non-disclosure agreements can serve a useful and legitimate purpose for employers, a number of cases have brought to light that these have prevented victims of sexual harassment at work from speaking out. Final proposals to prevent misuse in the future include legislating so that confidentiality clauses cannot prevent disclosure to the police, regulated healthcare professionals or legal professionals, producing guidance for the drafting of settlement agreements, and introducing enforcement measures for non-compliant clauses. We are nearing the end of this webinar, so let's just summarise the content that I have presented today. I hope you have found it useful and informative to take a detailed look at the sexual harassment part of a potential discrimination claim if not handled well at work. We looked at how sexual harassment is unlawful and that just through one single act of unwanted sexual conduct, an employee can be accused of this allegation. I confirmed how employers have a responsibility to prevent sexual harassment at work and therefore cannot ignore investigating such complaints. I described how unless you have a specific harassment policy, the grievance and associated disciplinary policies should be used to handle such a complaint. Where the result of a grievance hearing and investigation show there is a case to answer, I clarified how the disciplinary policy should then be used to formally deal with the matter. After explaining where gross misconduct has been committed, suspension or other alternatives should be considered. Clarification was proposed on situations where a victim wants to raise a matter but is concerned about it being handled formally. Investigation should still ensue. Finally, it was acknowledged that for all parties involved, dealing with a sexual harassment case is distressing. The right people should be selected to handle it, should have their own support, but most also appreciate that they should strike the right balance when dealing with those involved. And that is the end of our webinar today. For those listening and watching who are already clients of ours, thank you for joining us again today. And please do contact us in the usual way if you have any follow-up queries. If you aren't a client with us already, but would like to ask a question or are interested in our services, then please do contact us at enquiries@hrsolutions-uk.com. You can also use this email address to request a copy of our slides, and you can watch, listen, forward our webinar recording from today by heading to our main website at www.hrsolutions-uk.com and clicking on resources and then video and webinar archive. For our HR knowledge-based customers, this webinar will be posted shortly into our recent articles, and you can select our associated hot topic from the Keeping You Informed section. You can also view our guidance pages on the Equality Act, discrimination, and on harassment. Please sign up on our events page on either our knowledge base if you have access or on our main HR Solutions website. These are the next 3 webinars we have planned. In December, we are looking at interesting case law from 2019. Then in January, we will be starting off the year afresh, having a look at what was new for HR in 2020. And in February, we have planned a webinar on the VE Day and tips on bank holiday entitlement. All I have left to say is thank you for listening, and I hope you found today's webinar informative. Thank you.